All right. Everybody, thanks so much for coming. I just want to make one small announcement. This presentation was prepared for a guy named MJ Bogatin. He's sitting over there to your right. I am not MJ Bogatin. My name is Matt Didon, but we're giving him a chance to save his voice because he gave the presentation just a few minutes ago. Okay, so let's get started. We're going to be talking about copyright. So copyright is a legal right accorded by federal law to the creator of an original work of authorship fixed in a tangible medium. Now, this was created, you can thank Thomas Jefferson and a few others for it, but the idea was to promote the progress of science and useful arts by securing for limited times, it was only supposed to be for a little bit, to authors and inventors the exclusive right to make use of their works. And so that was in Article 1, Section 8 of the Constitution, and right now it's codified at Title 17 of the U.S. Code. So it does that by giving a limited monopoly on copying creative expression. So right now, copyright applies to, under Section 102, literary works, musical works, dramatic works, pantomimes and choreographic works, pictorial, graphic, sculptural works, film, AV, and the list goes on and on. It's not necessarily an exclusive list. There's quite a bit that can fall into this. Copyright gives you 5 exclusive rights. It's the right to reproduce, distribute, do public performances, display, and make derivative works, including digital audio and text and visual transmissions. So if you think RDDDP, the mnemonic that I use is rabid dogs don't dance poorly. You'll remember that one, but I do feel bad about the dogs. There is something called the first sale doctrine that you need to be aware of. And so basically for a physical copy of a work, once you sell that, your right to then redistribute that one physical copy is severed. You being the author cannot go grab that copy back from whoever bought it and then give it to somebody else. There are a few businesses that have based their entire models on this. A few that come to mind are GameStop, that sells video games, and another is Half Price Books. These models are dying lately because of how digital distribution is starting to really ramp up. It's just super convenient. So maybe don't buy stock in them if you have the opportunity. So the next thing we're going to touch on is divisibility. Copyright interests are subject to division. So those 5 rights that I mentioned, any one of them can be given to somebody else. It's a licensing thing. So there's going to be a contract involved, but they can be divvied up however you want and given to whoever you want. Like if you think Marvel Entertainment, now owned by Disney, but Marvel does this a lot with its movies. Somebody owns Spider-Man, somebody else owns the Avengers, and it can all be horribly complicated because you can just give these rights away willy-nilly. So let's talk a little bit about the scope of copyright. So copyright is distinct from the physical ownership. Remember I mentioned the first sale doctrine? So a copyright is not necessarily you possessing the physical object that you created. So this awesome presentation that's been created, the copyright to this presentation is not in the presentation itself. I could hand this out to one of you, but I would retain the copyright to this presentation. Well, Bo would. Bo would retain the copyright to this presentation. So there's something along these lines that's called the expression versus idea dichotomy. It is expression that is protected, not an idea. So if you have the idea for a fantastic story, okay, it's going to be a young man who his caretakers are murdered, but a mysterious old man shows up, gives him a mysterious, powerful weapon, and then they have to go rescue a princess, and they defeat some sort of evil organization. What did I just describe? Nope, it was Kroll. But good try. You see, several things can take that idea of the story and then make their own story out of it. And that's not copyright infringement. You haven't messed up anybody's rights. But it's the expression that is protected. So for example, if you made a story where it's a young man who's given a laser sword and he can use space magic and he has to go and overthrow an evil organization who happens to wear spiffy armor and shoot laser guns, you're going to get sued by Disney. You don't want to be sued by Disney. So a good example that Bo likes to bring up is the Franklin Mint case. This drawing over here on your left, I guess, is the original, and this is the copy. These drawings are both done by the same guy. So he was hired by one organization to create a copy featuring a cardinal. And then a few years down the line, that relationship soured, and then he was hired by the Franklin Mint to do another drawing. And so he used some of the same source material to make that second drawing. Now, you can see there are some small differences between these pictures. And so there was a lawsuit, and it was decided that no, this is not copyright infringement. In this case, it was mainly the idea that's being represented, so the expression itself was not violated. Also, when it comes to everyday creatures, animals, and stuff like that, there's not as much protection as you can get for those pictures of them, just because they're factual creatures. There's only so many ways you can paint a robin, or in this case, a cardinal. Okay, the last note that I want to give on that is that when you are creating something, to be protected, your expression only needs what's called a modicum of creativity. So you only need a little bit of originality to be protected. But let's say you want to draw a cardinal, like one of these, and so you put your blood, sweat, and tears into that. You spend 2 years on it drawing the most realistic cardinal you possibly can. Well, you cannot get that copyrighted. The copyright does not award what's called sweat of the brows, or effort. So even if you put a lot of effort into something, as long as that particular thing cannot be copyrighted, no matter how much time you spend on it, you're not going to get it protected. Okay, let's move along to the term of copyright. So when copyright first started out, way back, just a few years after the United States started out, you got maybe 14 years of protection. These days, it is the life of the author plus 70 years. In 1998, it was extended by the Sonny Bono Copyright Act, or the Copyright Extension Act. But if you were not fond of the act, it was known as the Mickey Mouse Extension Act. Because around that time, in 1998, Mickey was going to lose his protection because Steamboat Willie, the cartoon that he first appeared in, was going to run out. So Disney and others lobbied against this, and it was extended to life plus 70. They got another 20 years. If you go to CLA's YouTube channel, there's a fantastic presentation about Mickey Mouse on there, and I really recommend it. If your copyright is a work made for hire, then the term is a little bit different. It is the shorter of 95 years from the year of first publication, or 120 years from the date of creation. The shorter of those two. And we're going to talk a little bit more about work for hire later. Okay, so there are other terms for works that were registered before 1976. Those are still technically under the 1909 Act, and it gets a lot more complicated. When a copyright term ends, the works automatically fall into what is called the public domain. If a work is in the public domain, anyone can do whatever they want with the work. You can't really take anything out of the public domain. There was only very rare instances where that might have occurred, and I think it happened once for foreign works, but it was extremely limited. A good example of this is the Pride and Prejudice and Zombies book that came out a little while ago. The author of that, he took Pride and Prejudice, and then he added some sections to it that turned Elizabeth and her sisters into a zombie fighting force. And they made a pretty good movie out of it too, so you might want to check it out. Let's skip along to works made for hire. When it comes to a work made for hire, you have to remember that copyright is going to usually belongs to an author. But if you have an employer, your employer is treated as the author of the work. The copyright belongs to them. There's two ways to make a work for hire. Ownership is going to vest in the hiring party upon creation. So if somebody's your employee, you will get their work, as long as it's part of their duties. Or if you commission a work from somebody who's an independent contractor, then it can also be a work for hire. Now there's 8 enumerated categories within that statute for independent contractor works. In that independent contractor agreement, you have to use explicit language that this is a work for hire if you want it to be a work for hire. Now, when it comes to whether or not somebody is an employee or an independent contractor, that can get a little bit muddy. It comes down to who has control over the work and whether you can dictate the means by which the work is performed. And there's a number of factors involved in that. There's the skill that's required, there's the source of the materials that the independent contractor uses or the employee uses, where Where was the work performed? Was it performed at the employer's office, or could the person do it at their own home? How long was the person working for them? Was it for years, or was it for over a weekend? Stuff like that. How were they paid? Were they given benefits? And then basically, who could dictate how the work was done? That is what it usually comes down to. There have been a lot of disputes in the past over whether or not somebody is an independent contractor or an employee, but it's starting to clear up a little bit. There's been some movement. So there's California's, I think it's the Assembly Bill 5, should be up there, which is following a case called Dynamex. And so that case was decided a year or two ago, where they made it much more difficult to be an independent contractor. California now follows an ABC test. It's just a 3-factor test of determining who's an independent contractor, and it's very, very difficult for people to be an independent contractor under this test. There's only a few categories which are exempt, and I think you have to be either a doctor, a lawyer, an accountant, or an engineer. I'm probably missing one in there to be exempt from that test, but it's going to be harder to be an independent contractor. So when it comes to the copyright formalities, copyright protection automatically vests upon the creation of the work. So as soon as you put pen to paper and you write your poem, boom, you've got copyright. There used to be something required called notice. When you first published your work, at least under the 1909 Act, you had to put notice on your work. A notice is the circle C and the date and then the name of the person or persons who came up with the work. Now, under the 1989 Act, you no longer needed notice. That's because around that time, the United States joined the Berne Convention, and under the Berne Convention, you're not supposed to have formalities, so that part was dropped. So you no longer need to have a notice when you publish your work, but you should put it on there, and the reasons why are when it comes to infringement. And we're going to talk a little bit about copyright infringement later, but just keep that in your head that you should put the notice on it because it will help you if somebody steals your work. When you create a work, great, you have copyright, but you can't enforce it. If somebody steals your work right after you've created it, you can't sue them. You need to register your work first. You do that by going to the copyright.gov website, and you can fill out an online form right there, or you can fill out a paper form. I recommend going online because it's much cheaper and it's much faster. If I recall, the processing times for an online form are about 3 months, and the processing time for a paper application is about 8 months. It's more like a year now. Okay, great. Do the online form if you can. So when it comes to that notice that I mentioned, that circle C, the reason you want to put that on there is that if somebody takes your work, but it's got that circle C and the date and your name, then they cannot claim that it was an innocent infringement. They can't say that, oh, I had no idea that this belonged to somebody else. No, it's got your name on it, so it's proof that it's yours. They can look at that, and that can greatly increase the amount of awards that you can get. You can get statutory damages. Now, you can only get statutory damages if you register before somebody then infringes your work. So register your works very soon so you don't run into this problem. There is an accelerated form and things that you can fill out to get registered if you do it within the first 3 months after somebody infringes. But that costs more. It costs, I think, $800 to do that particular form. So you want to be registered before somebody infringes your work. So if you're going to publish, well, some publishers, they like to register afterwards, but if you're going to self-publish, register before. Register before you publish. You could also put copyright or COPR. It doesn't have to be that C, but it's got to be one of those things. And it doesn't have to be the entire name of the person, but it needs to make the person who created it identifiable. That's the key. So they need to be able to figure out who did it. So here's a piece of paper with ink on it. This is a tangible medium. You can hold it, and it's not going to disappear from the paper anytime soon. Pressing your hands into wet cement or writing your name in wet cement, that's also fixed in a tangible medium. Writing something on a computer in a word processor and saving it, that's also a tangible medium. It's not going to disappear anytime soon. What would not be a tangible medium? Making a snowman when the temperature is rising. making a sand castle, because that's probably going to get swept away pretty soon. These are not tangible mediums. Joint works. A work can be prepared by more than one person. Some of you have probably worked on a project where it's got several of you putting together a big sculpture or putting together a film or working on a song together. So in the absence of any sort of agreement between the people who put it together, this is a joint work, and each of you have equal control over the copyright. Now, does this mean that everybody needs to agree on who they're going to do business with the copyright, who they're going to license it to, who they're going to sell it to? No. Anybody who has a part of the copyright can do whatever they want with it. Bo likes using the analogy of a car with 2 keys. And so anyone with one of those keys can just take the car and run with it, and they don't need the permission of the other person. This is not a good thing. This way, one person can ruin an entire project for a group of people. How do you deal with this? You need a contract. You need a contract between the creators that says who has what rights. And so I think there's a Star Trek Enterprise over here, and there's something there, an instruction that says, ask Matt about the Star Trek story. So back in the day, a guy named Gene Roddenberry created a show called Star Trek. It was pretty popular at the time. Now, the guy that they hired to do the music was a guy named Alexander Courage. In addition to having one of the best names I've ever heard, he was a well-known composer. And in his contract, the composer for the show would get royalties. So Gene Roddenberry approached Alexander and he says, you know what, how about we make some lyrics to this song? And so Courage was pretty sure that the lyrics would never be used to the opening to the show, so he just said, sure, Gene, whatever makes you happy. And so when it came time for the royalties to come in, Alexander said, hey, wait a minute, I'm only getting half my royalties. And then he discovered that, well, by agreeing with Gene to let Gene write the lyrics to the song, they now had a joint work because they intended to work together, and therefore Gene got 50% of any royalties, and he was able to just plug that back into the Star Trek show. And to his dying day, Alexander Courage cursed Gene Roddenberry for screwing him out of 50% of his royalties. So know your rights and get a contract. That's the moral of that particular story. It is possible to transfer copyright or sell it by using what's called an assignment. This is also usually some kind of contract. When you do an assignment, that has to be the entire copyright. If you're just doing one of those 5 rights that I mentioned, that's a license. But if you're doing the entire copyright, that's an assignment. This has to be in writing. Can't be oral. Now, if there's an exclusive license, so if one of those rights that I mentioned, but it's going to be exclusive to whoever you're giving it to, that's also got to be a writing. If you just say to somebody that, sure, you can use it, that's non-exclusive. You can then give that license to anybody else. And now we're going to talk about copyright infringement. Copyright infringement is when somebody interferes with your use of your copyright. Usually this is done by them violating one of those 5 rights that I mentioned. And these days, it's usually somebody going online, finding a picture of yours that you've put online and using it for whatever. Now, in order for you to prove that somebody is infringing your work, it's fairly simple, but when it actually comes to trial, it can be horribly complex. But you need to have ownership of a valid registered copyright, so register your copyrights, and the copyright has to actually be protectable. The expression has to be protectable. Like when you go to trial, one of the first things that the defendant is going to argue is that, nope, that expression is not actually copyrightable, therefore they should lose the copyright. But if your work is original enough, you can show that, yes, indeed, it can be protected. Once that's out of the way, you then need to show that the defendant had access to your work and the works are substantially similar. Now, Bo has an example of one of his clients took a picture, well, I think he got a model of a guy standing on, was it like a 40-story building? So a 40-story building looking straight down with the tips of his shoes just sticking over the edge. Camera, click. Just imagine what that felt like. I hope he had somebody holding him on the back. And so there was a shoe company that saw this picture and really liked it. It's a very striking picture. And so they approached him and they said, hey, can we use this picture? Just we'll put some of our shoes on the model's feet. And he said, sure, here's my fee. And they said, oh, you know what? never mind, we don't need to do this. And then a little while later, lo and behold, there's a picture of somebody looking, with the picture straight down with, the shoes on the feet. And so, of course, Beau's client sued. Now, we're going to talk a little bit about that idea-expression dichotomy. Now, if they had just gone to, let's say, a different building, and then put the shoes on the model's feet, and then looked down and taken the picture, and nothing else, that might have been okay. That might not have, they would have used their own expression just with the same idea. But they didn't do that. Instead, there were several similarities to the picture. There was 15 similarities to the original picture that Beau and his client were able to point to say that, no, look, they just directly ripped us off. All they did was change the shoes on the feet, pretty much. And so that was infringement. There's a seminal case in this particular area, which I think it's Feist Publishing versus Rural Inc. And so in this case, this company called Rural was making a whitelist of phone numbers from all its subscribers. And this company called Feist comes along, and they wanted to buy out Rural because they were buying out everybody else in the area, and Rural refused. So Feist went and did it anyway. They copied 4,000 entries from Rural's phone book. And Rural had put in several fake phone numbers into the phone book. So when they saw that Feist had copied them, they were able to point and say, look, that's infringement. Rural lost that case. Now why? This is because facts cannot be copyrighted, and phone numbers are just facts, and they were just laid out in a list. Now, if they had done something clever with that by putting snazzy colors or putting it in a neat font or something like that, they might have had more protection, but just the phone numbers themselves, not copyrightable. So just keep that in mind if you're going to sue somebody or you're getting sued. How do you defend against a case of copyright infringement? Perhaps the most important thing to know that's not listed up there is that a lack of knowledge of infringement, for example, saying, oh, I didn't know that this picture was copyrighted, that won't save you. You can't argue that, hey, I had no idea that I was ripping off somebody else's work. Now, if you're able to prove that what you have done is called innocent infringement, that you truly had no idea, then that's going to limit the damages that you could potentially recover from that case, but you're still going to get sued. Now, if you had put that copyright notice on that we talked about earlier, and somebody rips off your work, they really can no longer claim that it was an innocent infringement. It's got the Circle C, it's got the date, and it's got your name on there. And so if somebody rips off your work and said, oh, I had no idea that it was copyrighted, that's not going to work anymore. And so then you can get rid of that innocent infringement defense and then sue for the maximum. Well, you can try to sue for the maximum. Now, what is a valid defense? Number one, you had a license. Great. Number two, this is where you have a bunch of little subheadings. There's a 3-year statute of limitations when it comes to copyright infringement suits. So if somebody ripped off your work and you should have noticed it 3 years ago, but you didn't bring suit, then you're in trouble. Usually that would bar you from then coming after them. However, if they continue to use your work, and they continue perhaps to make money off of it, but if they continue to use your work, you can still sue them, but you can only sue them for damages. You can't sue them for an injunction. You can't stop them. You're only going to get damages, and you're only going to get actual damages. So actual damages means the money that they have made or that you would have made if you didn't have to deal with this infringement. Actual damages are very difficult to prove. Let's say you're Stephen King and you put out a book every year somehow, and you are able to make a very consistent return on these books. You're able to show that I'm able to make this much this year, and it's usually about that. It's like an average. Every now and then he'll get like a super big hit. Now let's say somebody infringes his work and there's a noticeable dip in that chart that he's got. In that case, he could probably prove actual damages. My name is not Stephen King. Most people's names are not Stephen King or J.K. Rowling or somebody else who can show that they've got this stable income from these things. In that case, you're in trouble. You're going to have a lot harder time proving actual damages. You want to get those statutory damages, so register your copyrights and use that copyright notice. I'm going to keep harping on that. Now remember, the other one that's up there is if unprotected material was copied. So remember when I said that facts cannot be copyrighted. One thing that they're going to argue is that, no, what you had there was actually factual based or something like that, and therefore it should not be protectable by copyright. So therefore your entire copyright should be voided and I should be free to use the thing that you created however I wanted. That's something that they're going to argue as well. That doesn't always work. So there's a line of cases. It started in Mazer v. Stein with this. This is a lamp. You can't really tell. It looks kind of like a sculpture. And so what Mazer v. Stein, in that case, there was a lamp like this that was copied, and it was argued that they violated the copyright, and the defendant argued that, hang on, this is a useful article. Usually when it comes to a useful article, that has to be protected by a patent, not copyright. It's, copyright is reserved for artful stuff. However, it was held that if you can separate the artful from the useful article, then the artful part of it can be protected in this case. The most recent case to rule on this was a case called Star Athletica versus Varsity Brands. And so this was a case of cheerleader uniforms. And so what happens was one company ripped off a design that was on a cheerleader outfit, and the first company sued. And they found that as long as the design can be taken off the cheerleader outfit, then it can be given its own protection. And I think as part of that case, they explicitly did not rule on whether or not the designs that were ripped off were able to be copyrighted, but they just wanted to say, yes, it is possible to protect designs that are on a cheerleader uniform. One reason why they left the question open on whether or not those designs could be copyrighted is that when it comes to simple geometric shapes, usually you have a much harder time copyrighting those. If you just put a square, a blue square in a piece of paper and tried to copyright that, that's not going to fly. That's just a basic geometric shape. But let's say you're a fan of Cubism and you or Pablo Picasso, and you've made a great painting that happens to use some geometric shapes in there, that's probably protectable. There's 4 tests used when it comes to this expression idea. First up is the mind of the designer. What was he considering when he made the art? Then the use test. Whether or not the use is a utilitarian article as opposed to art. Is it a lamp? Is it a traffic cone? Or is it supposed to be more artful? The perception test, and that's which is favored, the aesthetic aspect or the utilitarian aspect. What is it meant to be? Is it a lamp in the shape of a leg with a high heel on the end? Is it made to be looked at, or is it just made to illuminate the room? The art market test, that's a substantial likelihood that even if the article had no utilitarian use, would there still be a market for it due to its aesthetic qualities? Do you guys remember that old movie, The Christmas Story? That lamp that I mentioned, the dad gets a lamp with It's a major award. It's a shapely leg with a high heel.
Electric sex gleaming in the window.
If you were to get one of these novelty lamps, would you get it just to light up your room? Or would it be a conversation piece that people would come in and comment on, and you can say, hey, check out this weird looking lamp that my wife hates?
I was watering my plant and I broke your lamp.
Probably the latter. So in that case, it's probably more artful. Let's move on to fair use. And I'm really glad that Bo included this in his presentation because it comes up a lot these days. I see it a lot on YouTube these days. Somebody's going to put up a song that they didn't make or a video that they didn't make, and then in their little comment box they're going to say, my use is fair use, so you can't sue me. That's not quite how fair use works. So fair use is a defense that you can bring forward when you're sued. It's known as an affirmative defense. Now, I know in the Ninth Circuit there's some movement that it might be something you can assert beforehand, but across the United States right now it's something that you usually just assert after you've been sued. A fair use is something where a use can be legal if it's used for purposes such as criticism, comment, news reporting, teaching, or scholarship research. I've used a few pictures in this presentation purely for educational purposes. In that case, it's likely fair use. There's 4 factors that you need to consider when determining whether a use is fair. The purpose and character of the defendant's use. Was it commercial? Was it non-commercial? I'm certainly not making any money off this presentation. The nature of the copyrighted work. So was it published or unpublished? If it's unpublished and somebody ripped it off, that's going to count against the person who ripped it off, like a lot. Was it nonfiction or fiction? Is it fact-based? Or was it something somebody made up? If it's more fact-based, that it's going to be closer to fair use. The amount of work used relative to the whole. Did they take a huge amount of the work or just a little bit? Now keep in mind, in this particular factor, if it's just a little bit, that doesn't necessarily mean that it's fair use. When Gerald Ford was going to publish his memoirs, there was one organization that they took a passage, just like 300 words out of like 200,000, and they published it, but it was found that that particular passage was the heart of the work. It was the most important part of the book, and that was found against them. Also, it's Gerald Ford, so that didn't help the defendant. And finally, the effect on the market. These days, it's very important. Did you cut into the market of the original work? And that's very much against you if you start taking customers away from the original market. We're going to end talking about parody. So we have parody versus satire. Can you tell the difference? It's hard. Parody, which is protected, it falls under fair use. So parody refers specifically to the original work, and it makes fun of that original work. Spaceballs makes fun of Star Wars. Spaceballs is a parody of Star Wars. It uses only so much of the original work to make the point. If it goes beyond this, well, then you're infringing because you're just taking work. Satire, on the other hand, makes fun of either somebody or society as a whole. It makes fun of somebody that's not the subject of the work that's being used, or it just makes fun of society as a whole. Parody is protected, satire is not. This picture is Demi Moore. This picture is Leslie Nielsen, in case you can't tell the difference. This picture was taken by Annie Leibovitz for the 1991 Vanity Fair, and then a few years later, the third Naked Gun movie came out, and so they put Leslie Nielsen's head on a body double in the same pose as Demi Moore when she was pregnant. So Annie Leibovitz didn't really like this, so she sued, but that was found to be parody. They said that, going through the factors, the purpose of the work was to make fun of serious art. It was very transformative. It was therefore highly creative. This certainly seems to give off a much different vibe than that does. For example, Demi over there has this incredibly serious look on her face. It's a very, very artful, beautiful shot. And then over here, you've got Leslie Nielsen's head on a pregnant woman's body. Was a substantial amount of work used? Yes. I mean, it looks almost like her exact body, and it's just the heads that are different. But in this case, the court said that this only heightened the ridiculousness of the poster. I certainly think so. Did it have any effect on the commercial market? No. It had no effect whatsoever on the market. It did not cut into this photo at all. Indeed, it might have made people go and look at the original photo as opposed to just, taking this one. A few other examples of parody. One of the big cases that kind of really highlights this was the Campbell versus Acuff Rose. In this case, there was the rap group Two Live Crew, and so they took a few lines of Roy Orbison's Pretty Woman, and then they flipped it around. I think I can't say the lines because they use a lot of stuff, so I better not touch on that, but they said that in that case, the song was transformative. It was very much making fun of the original and kind of pointing out the over-seriousness of the original and getting them to lighten up a little bit. And I think we are just about out of time, so do we have any questions? So you're not getting very much of anything from the Writers Guild. Most of the protection you're going to get is from copyright. One of the things that you can get from registering the Writers Guild is if somebody infringes you, you can then go and say, look, I registered my work with the Writers Guild on this date. So we know that I had completed my work on this date. They've completed their work on this date, so you see mine came first, and we can then take my work and say, look, it was completed on this date, this is the form it was in, these are the similarities between the works. It mainly helps your timeline, but that's about it. Okay, so on the copyright form, the online copyright form, there are options to do that. In fact, if you go there and you try to do that, they have videos which explain how to do that. Now, you have to go to the copyright website, you'll have to make an account with them, and I recommend that you read the circulars beforehand. Then for certain groups that meet certain requirements, for example, if you're the author, if you're the only author and you did all the work in the same year that it was published, then there's a certain form that you can fill out where you can put in a bunch of stuff under one application. And then there's various forms for different groups like that that you can fill out. It's complicated, but it's very doable. And you can use the online form. It's cheaper than using the paper form. That's a good question. That will depend on the work itself, and that's going to be something that people can argue. But what I would do is, when you send in a sculpture, you're going to have to send in some sort of picture of it. So you're going to send that in, and there's a place where you can kind of comment on the form to the copyright examiner. And that's where you're going to kind of try to give them some idea of what you're trying to intend. Okay, this is where it gets a little fact intensive. Now, when he brought these people together, did they talk about that happening? Did they talk about ownership, who's going to own it when they started working on it? To be very safe, what needs to happen is people need to get back together and come up with a writing, some sort of contract between the two of them. You can do this after the fact. It's better if you do it before the fact, but you can do it after the fact as well. Get them to come together and make a contract that says who gets what. Now, the people who did their particular section of this work, they could have an argument against it, but so could the person who organized the whole thing, in which case you could have a messy litigation down the line if that happens. So in order to be perfectly safe, you all need to get back together and come up with a contract that says what your rights are. Now, lawyers from California Lawyers for the Arts can help with that. If disagreements do happen, that's a great time to talk to one of those mediators that our executive director was talking about earlier today.
Thank you very much for watching. If you would like to see more videos by California Lawyers for the Arts, please like and subscribe to CLA's YouTube channel so we can provide full-service live streaming programs soon. Our channel will be producing videos that cover all kinds of artistic, entertainment, and intellectual property legal issues. You can also find our videos on Facebook and livestream.com.